So when a lawyer stands up in front of a jury, their job isn't just to lay out a bunch of facts, it's to tell a story so compelling that it actually leads to a verdict. But what is it that makes a story persuasive in the high-stakes world of a courtroom? That's the real challenge, and that's what we're going to break down. So what really moves the needle in the minds of a jury? Is it just a mountain of evidence? Is it a perfect, flawless legal argument? Well, according to the work of trial consultant Gregory Cusimano and Professor Blankenship, the answer isn't what most people or, even most lawyers actually think. When you're prepping for a trial, you're basically at a fork in the road. There are two totally different paths you can take. On one side, you've got the traditional top-down approach. That one starts with the law, the black and white text. But on the other side, there's a completely different strategy, the bottom-up approach, which starts with the people who matter most, the jury. Okay, so first, let's look at the classic playbook, the top-down method. This is how most lawyers are trained to think, and it's built entirely around the lawyer's point of view. This is what's called the toga approach, and no, it's not about the robes. It stands for top-down, object-based, goal-oriented. The whole process is pretty straightforward. You start with a legal framework, say the elements of negligence, and then you go hunting for facts that you can plug into that framework. The logic here is super linear, almost like building with Legos. Step 1, you grab the law. Step 2, you find the facts, the little bricks that support your legal claims. And then step 3, you build your argument to prove each one of those legal elements. It's a neat, tidy, totally deductive process. Remember the famous McDonald's hot coffee case? Well, a top-down lawyer would frame it as a simple syllogism, something like, it's negligent to serve coffee so hot it causes third-degree burns. McDonald's did that. Therefore, McDonald's was negligent. I mean, it sounds perfectly logical, right? But as we all know, trying that exact same case today with just that logic would be incredibly difficult. So what's missing? This quote from Cusimano and Blankenship's work just nails the problem. Lawyers think like lawyers. They reason like lawyers. And in doing that, they can become their own worst enemy because they assume a jury is going to see the world through that same legalistic lens. But they just don't. So if thinking like a lawyer is actually the problem, then the solution has to be a completely different way of thinking. So what is the alternative? Okay, let's walk down that other path. The bottom-up approach completely flips the script. It requires this huge, fundamental shift in perspective, away from the lawyer's world and right into the world of the jury. See, the bottom-up approach doesn't start with the law. It starts with a question. How is the jury going to react to these facts? What do they already believe about how the world works? The whole core of this process is listening to what jurors think is important, not just what the lawyer thinks is important. Think about it like this. Don't fight the current. Instead of trying to force a river to bend to your will, you figure out which way it's already flowing and you paddle your canoe in that direction. It's all about positioning your case to align with the jury's existing currents of belief. And the psychology behind this? It's absolutely fascinating. We all have these mental shortcuts or frameworks, they're called schemas, that help us make sense of the world. So when we hear a story that clashes with those deeply held beliefs, it creates something called cognitive disequilibrium. It's that feeling of confusion and anxiety, and people will instinctively resist that feeling, which is why it's so much more effective to align with their beliefs than to try and shatter them. But look, this isn't just guesswork, right? It's a really rigorous, active process. You're constantly trying to discover what those juror schemas are, developing your trial story, and then testing it with focus groups and research, and if it doesn't work, you don't just push harder. You revise and you rebuild. So what's the ultimate payoff for all this different thinking? Well, it's the difference between relying on a rigid formula and mastering a flexible process. In this table here, it just weighs it all out so clearly. A top-down lawyer asks, what does the law say? But a bottom-up lawyer asks, how will the jury see this? One uses deductive logic, trying to prove a conclusion they already have. The other uses inductive reasoning. It's like being a detective, gathering clues from the jurors themselves to build your theory. It really is a shift from a rigid lawyer-focused formula to a flexible juror-focused process. And the benefits of this process-driven approach are just huge. Because it's not a rigid script, you can actually adapt when a trial inevitably throws you a curveball. Your confidence isn't just based on some legal theory, it's grounded in real research about how real people think. And best of all, these principles work whether you're arguing a small claims case or some massive corporate lawsuit. And here is the crucial difference, the bottom line. A formula is brittle. It can shatter the second a witness says something unexpected. but a process, a deep understanding of the why behind your story. That gives you the power to improvise, to adapt, and to truly meet the moment, no matter what it brings. So, what's the big takeaway from all this? It's about so much more than just a technique. It's about a fundamental shift in mindset from simply presenting a case to truly owning the trial story. This simple quote from Gregory Cusimano just says it all. See, when you just memorize a formula, you can forget it under pressure. But when you deeply understand the principles, the psychology, and the story, you don't have to remember it. You just know it. You own it.
And really, that's the final distinction, isn't it? Are you memorizing a case, just following a formula that could fail you at any moment? Or are you owning a case, understanding the process so deeply that you can't forget it, because it's just become part of how you think?
This isn't just about the courtroom. The art of persuasion is all about understanding your audience, whether that's a jury, a client, or even a colleague. So thinking about these two approaches, the top-down and the bottom-up, how would you tell your next important story?